Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. This video, I want to talk about child abuse charges in San Diego, most commonly filed under Penal Code Section 273A. And the most common type of child abuse charges we see in San Diego are not what you might think. A lot of times people think child abuse, you think, corporal punishment, smacking a child, spanking a child, just outright abusing a child. And as terrible as that is, and we do see those types of charges come through, the most common type of child abuse charge we see, especially in San Diego, has been attached to a DUI. Situations where the parent or the caretaker of the minor, someone under 14 years old, for purposes of child abuse charges, is in a car, and the mom or the dad, the brother, the aunt, grandma, whoever, could have a traditional misdemeanor DUI, but for the fact that there was someone under 14 in the car, they're now charged with felony child abuse. And a lot of times people wonder, and they say, well, why is it child abuse if no one got hurt? Well, they could have been. And basically you put that individual, the accusation is that you put that minor in a situation where their mental and or physical well-being could have been greatly injured. So you're on the hook for child abuse, and it's likely filed as a felony. So what normally would be a misdemeanor DUI, now you're dealing with the misdemeanor DUI, but you're also dealing with felony child abuse. Now, the good thing is that even the child abuse charge under Penal Code Section 273A can be reduced or even charged separately as a misdemeanor. So let's talk about what are some of the factors that a district attorney in San Diego will look at to determine whether they're going to file felony child abuse charges or whether they're going to charge misdemeanor child abuse charges. One of the most common things is prior criminal history, if any. Obviously, you have less of a criminal history, you have a better chance of it being a misdemeanor versus a felony. Another main factor is obviously, was there an accident or not? Right? Was a child actually hurt? Could have the child been most likely actually hurt because there was in fact an accident versus going through a checkpoint or getting pulled over without any actual injury imposed or without any collision? And then also, what was the blood alcohol level of the driver, right? So if you're barely at the legal limit, you're at a 0.08, 0.09, 0.10, no really bad driving, traditional low alcohol level first-time DUI, well, you have a better chance of the case starting even as a misdemeanor child abuse case. But if you're 2-3 times the legal limit, you can expect to be charged with the felony child abuse charge. Doesn't mean that's how the case is going to wind up, but at least it's going to start that way. And the best thing you could do at that point to ensure that you walk out of this without a felony charge, certainly a felony child abuse charge that no one as a parent or as a caretaker ever wanted in a record for a number of reasons, is to protect yourself, protect your future, protect your freedom, protect your reputation, professional licenses, whatever you hold near and dear to you, by making sure you go all in with the best locally experienced criminal defense law firm possible who could guide you through this process to tell you how you could get out of this with the least amount of damage, both short-term and long-term. We are just one phone call away to get that process started. 619-295-3555.